Could you state your name?
Tyler James Robinson.
Recognize that we are here today for a waiver hearing. It is not our intent to waive a preliminary hearing in this matter. We are going to be seeking that one be set. However,
Mate looked under the keyboard and found a note that stated,
A shocking revelation shook the courtroom as the accused shooter in the Charlie Kirk case spoke. Witnesses froze and lawyers reacted quickly. The hearing took an unexpected turn, raising questions about the trial's direction. Experts warned that this new information could alter the case, leaving the outcome uncertain as the nation watches. Chapter 1: The shooting and case background. Court proceedings surrounding the man accused of shooting Charlie Kirk have become a focus of national attention. At the center is Tyler James Robinson, charged in connection with the shooting at Utah Valley University. Court documents confirm that the attack took place in front of 2,000 to 3,000 students, many of whom may now become potential witnesses. The sheer scale of the event means the trial will be closely watched across the country. From the moment Robinson was identified, the case carried weight. Kirk, as head of Turning Point USA, was both celebrated and criticized, admired by supporters as a defender of conservative youth and rejected by opponents as a divisive figure. His sudden death ensured the case would resonate far beyond Utah. But as the hearing unfolded, it wasn't the politics outside the courtroom that made news. It was the legal process inside. Chapter 2: Inside the courtroom. On October 3rd, Robinson appeared for what was expected to be a routine waiver hearing. Typically, defense attorneys either waive the right to a preliminary hearing or request that it be scheduled. Robinson's team chose the latter. They refused to waive the preliminary hearing, meaning prosecutors will eventually need to present evidence in open court. The state acknowledged the challenge ahead. Prosecutors described the discovery, evidence handed to the defense, as voluminous to say the least. They noted that the first batch would be delivered within 5 days, but more would follow. Then came the surprise. Robinson's attorneys said the discovery was so large, especially the massive amounts of digital material, that they needed more time before any hearing could proceed. In their words, until they understood the scope of evidence, they couldn't even estimate readiness. The judge agreed to delay. The next court date was set for October 30th at 10 a.m. What seemed at first a procedural step became a clear sign that this case will not move quickly. Chapter 3: The Discovery Battle. The heart of the unexpected turn lies in the discovery phase.
roommate looked under the keyboard and found a note that stated, quote, I had the opportunity to take out Charlie Kirk, and I'm going to take it. Police found a photograph of this note. After reading the note, the roommate responded, what?
Under Utah's Rule 16, the state must share with the defense the evidence used in filing charges, and it must be done within 5 days of request. In this case, the discovery is far from ordinary. Thousands of people were present at Utah Valley University during the shooting. The prosecution admitted many potential witnesses are still being identified. This means new names will continue to surface for weeks, if not months. The defense, for its part, stressed the volume of digital records yet to come. That includes surveillance, video, phone footage, emails, and investigative files. All of it must be reviewed carefully before Robinson's attorneys can prepare arguments. The state raised another practical issue. A pre-trial publicity protection order was issued over the weekend, restricting how attorneys and teams can communicate about the case. They asked how this should apply to the thousands of witnesses still being identified. The judge ruled that, as new witnesses are found, each must be informed of the order. This discovery battle is more than paperwork. It will shape the pace of the trial, the arguments each side develops, and ultimately how long it takes before a jury hears evidence. Chapter 4: What the judge made clear. As both sides debated timelines, the judge used the moment to underscore several principles.
Joking, right? I gotta grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I am sorry to involve you.
First, he emphasized that Robinson is presumed innocent until proven guilty beyond a reasonable doubt. That presumption, he reminded the court, is not optional. It is the foundation of the justice system. Second, he addressed victims' rights. Quoting the Utah Constitution, he noted that victims are entitled to fairness, dignity, and respect, and they must remain free from harassment or abuse as the case proceeds. Third, he pledged impartiality. His words were clear: I will not put my finger on the scale of justice. He promised transparency, fidelity to the law, and fairness to both the state and the defense. Finally, he ruled that Robinson must continue to appear in person for hearings, unless otherwise decided. This ensures he is fully engaged with his attorneys and able to participate directly in the process. These remarks were more than procedural. They set the tone for how the trial will move forward carefully, transparently, and with equal weight given to the rights of both sides.
No, Your Honor, thank you.
No, Your Honor, thank you.
As we are at the beginning of this case, it is my intent to only speak when I'm needed or it is necessary. But today I do wish to provide guidance and expectations that you can have for this court and wish to enter an order as well. As this case moves forward, Mr. Robinson's constitutional rights will be protected at every stage.
Chapter 5. Why this case matters beyond the courtroom. Although October 3rd's hearing was procedural, its implications are clear. The refusal to waive the preliminary hearing, the acknowledgement of voluminous evidence, and the defense's request for more time all confirm that this will be a long and complicated case. The presence of thousands of potential witnesses means delays are unavoidable. Discovery will be slow. Digital evidence will take months. The legal community will scrutinize not just each step, but also by the public. And because the case involves Charlie Kirk's death, attention will only grow. Every ruling, every delay, every argument will be watched by a divided audience. Supporters of Kirk will want answers and accountability. Critics will focus on whether the process is impartial and fair. The judge has already tried to insulate the case from political pressure. His reminders of innocence, victims' rights, and impartiality highlight that this is a court of law, not a political stage. But the reality remains, this is a high-profile case with national consequences. Whether it delivers clarity or fuels more division will depend on what emerges from the mountain of evidence now being reviewed. For now, the October 30th hearing is the next milestone, and the bombshell dropped in court, the sheer scale of discovery and the delay it caused ensures that the road ahead will be anything but simple. This case is just beginning, but it already raises big questions about justice and evidence. Will the October 30th hearing shift the trial? What do you think? Complexity or a legal tactic? Comment below, and don't forget to like, subscribe, and hit the bell for updates.